wife and I will probably undoubtedly die of broken hearts one day.
But my friend who killed my other two friends.
And I accept full responsibility for this horrible tragedy.
A man in Lewis and Clark County has been sentenced for his 5th DUI. William Allen French was arrested after witnesses reported him swerving into oncoming traffic northwest of Helena. A sheriff's deputy found French stopped in the eastbound lane of Lincoln Road shortly after. Investigators noted that French had bloodshot eyes and slurred speech, and his breath test showed a blood alcohol level more than twice the legal limit. In court, Judge James Reynolds sentenced French to 13 months in the Department of Corrections Adult Felony DUI Offender Program. He was also given a 3-year suspended sentence and fined over $5,000. A detective at the scene of a hostage situation at Caesar's Palace described it as the worst property damage he has seen in his career. The suspect, who appeared in court, is accused of kidnapping, with video footage showing him throwing furniture out of a 21 cent floor hotel window. This was the first court appearance for Matthew Mannix, during which prosecutors detailed the violent incident that occurred at Caesar's Palace. They also highlighted that Mannix has a prior conviction for kidnapping.
The court has concerns regarding the allegations that you have 4 active protective orders against individuals, and you have a fugitive hold from Colorado for a similar kidnapping conviction.
Mannix appeared in court in handcuffs, just 24 hours after he had barricaded himself and a woman in a hotel room at Caesar's Palace for 6 hours. According to court documents, investigators reported that the 35-year-old claimed he had a magazine full of rounds and threatened to pull the trigger. While officers did not mention finding a gun in their report, video footage we obtained shows Mannix throwing objects out of the hotel window.
I just heard like a big bang, and then I looked up, I saw somebody throw like an object.
Authorities report that Mannix and the woman he allegedly held hostage had been living a transient lifestyle on the Las Vegas Strip and had been using drugs heavily for several days. The woman told officers that Mannix had a knife, and she feared he might throw her out the window. A detective described the damage to the hotel room as some of the most severe new property damage he had seen in his 18-year career, with repairs estimated to cost over $50,000. The judge set Mannix's bond at $750,000, and his next court appearance is scheduled. A convicted drunk driver broke down in tears in court before being sentenced for killing an elderly woman. The victim, who was on her way to Sunday services, died a year ago. Charles Cucalenios, a resident of East Islip, sobbed uncontrollably as he hugged his family goodbye moments before hearing his prison sentence. Cucalenios, who was speeding while drunk, struck and killed 84-year-old Mary Regale, a beloved grandmother, Eucharistic minister, and Catholic Charities volunteer. She was hit on Carlton Avenue, not far from her home in Central Islip, while on her way to Sunday Mass.
She sounded like a saint.
She was a saint, yes.
Mary Regale, a mother of 10, grandmother of 12, and great-grandmother of 1 with another on the way, was the heart and soul of her community. She was the glue that held her loving family together, keeping them close and connected.
There's nobody like her.
Charles Cucalenios admitted in court that he was drunk on vodka while driving to a Sunday softball game. He was going so fast that he crossed into oncoming traffic and crashed head-on into Mary Regale. Prosecutors described his driving as reckless, with a blood alcohol level of 0.23, nearly 3 times the legal limit. In a tearful apology, Cucalenios expressed his regret and explained that his life had spiraled downward since the sudden death of his brother Philip.
So he's been suffering from alcoholism?
Not the whole time, but he's been battling with depression, and he's been, trying to move on, but he never really got past it.
The courtroom was filled with emotion from both sides as Cucalenios entered his guilty plea. The judge sentenced him to 5 to 15 years in state prison, sparing the Regale family from the ordeal of a difficult trial.
Justice was done.
She was the most wonderful woman, fully accepting of everybody, only loved.
Mary Regale's husband, Peter, passed away 5 months later, with the family saying he died of a broken heart. Jacques Underwood, the son of Chester County Sheriff Alex Underwood, appeared in court on charges of allegedly trafficking a kilogram of cocaine in 2012.
It's the case of the state of South Carolina versus Dwayne Arnaz Harrison and Jacques Trevion Underwood. As for Harrison, it's indictment 2013 GS 46-02041, alleging 1 count of trafficking in cocaine, 400 grams or more. And as to Jacques Underwood, it's Truebill's indictment 2013 GS 46-02073, alleging 1 count of trafficking in cocaine, 400 grams or more. Your Honor, for the record, there were other charges associated with both of these individuals. There's a burglary charge on Underwood and a failure to stop for blue light on Harrison. The state has elected to not go forward on those charges. We're just going to make it simple and just present the trafficking only. So I'll be filing a non-profit docket sheet on the other 2 collateral charges as they were.
So you're not going to follow on failure to stop the blue light?
That's correct, Your Honor. Not going forward on the failure to stop the blue light or the burglary. We've elected just to go forward on the trafficking with both defendants. And also for the record, Your Honor, these indictments were originally presented to the York County Grand Jury on June 13th of 2013. A true bill was rendered by the grand jury. And that indictment originally, as did the original warrant, only alleged that this occurred on October 30th of 2012. During my investigation of this case, it came to my attention that there is a broader conspiracy at play. We expanded the date range of the indictment to read September 30th, 2012 through October 30th, 2012 on both individuals. That was presented as an amended indictment on both individuals with these same indictment numbers on May 29, 2014, and a true bill was rendered as to both indictments. I don't know if it's necessary for us to have an arraignment on these, Your Honor, since conspiracy was alleged in the warrant, the original indictment, and in this particular case. I think it's more of a notice aspect. I provided copies to the defense, Mr. Rutherford and Ms. Moody, on June 4th, 2014. I sent them an email, a facsimile, and a copy in certified mail of the amended true bill indictments in reference to their separate clients.
Let me ask you, in the event, caution, your waiver of arraignment, or you want to be arraigned?
Your Honor, I would waive, however, I would have a motion as to move to dismiss the indictment based on lack of probable cause. I'm not sure whether...
Jacques Underwood was sentenced to 10 years in prison. A single deadly decision that can't be undone, one teenager is now facing the consequences for causing the death of another teen in a DUI crash. With their arms wrapped around each other and holding a photo of their son, the grieving parents took turns speaking in court, addressing the driver who took their son's life.
My wife and I will probably undoubtedly die of broken hearts one day, because we are broken, as she stated.
Alexander Brewer, who was 19 at the time, drove drunk and struck and killed 18-year-old Garrett Merriweather. Brewer had been preparing to leave for the Air Force, and the crash occurred after his going-away party. Since that tragic day, Brewer has consistently maintained his guilty plea.
I believe that I should go to prison, but I also believe that my actions aren't okay, but I do ask for forgiveness from the family.
The emotional proceedings reached beyond just the families involved. The judge visibly moved and shared a personal story of her own, stating that DUI cases are the hardest ones for her to handle.
Unit where good people make really, really bad decisions.
She went on to reveal that when she was 20, 3 of her friends were in a crash. One of them was driving under the influence and ended up killing another friend in the accident.
My friend who killed my other 2 friends, he took responsibility. He did what he was supposed to do, and when he got out, he became a firefighter in the hope that he could save many more lives than the ones that he took.
She encouraged Brewer to take responsibility for his actions and work to turn his life around, just as she had seen others do in similar situations.
I don't think that you're a monster. I don't even think that you're a bad person. I think you're a good person that made a really, really horrible decision.
Garrett Merriweather's parents are striving to find some meaning in the midst of their loss. They organized a run in his name, raising over $25,000. The money will be used to create scholarships for teens who share similar interests to their son. Comedian Artie Lange appeared before Superior Court Judge Nancy Civilli in Newark for a probation violation. Lange is currently serving 4 years of probation after pleading guilty to heroin possession.
Defendant tested positive for benzos, amphetamines, cocaine, and Suboxone.
Okay, and I understand for the first two that Mr. Arleo, he has a prescription for those?
Yes.
That's what he-
The state believes that the only way that Mr. Lange is going to be able to succeed is if he's ultimately in an 18-month to 2-year type program. I understand that drug court might be an option, but ultimately it comes down to his ability to want to do those things.
I have to agree. I mean, jail is not the answer, in my opinion. However, I think something is needed that's more than a short-term program. I've discussed it with him. I think drug court at this stage is probably the best remedy, recognizing that it's going to be a long road, and he knows that this is the end of his road.
Can I say one thing? I just want to say that.
If it's okay with your attorney.
I just wanted to say, I wouldn't be arrogant enough to come in here after using cocaine for 2 days. It's in my system, it shouldn't be. Heroin is out of my life, and I'm happy about that, and I'll do anything you say, and I respect the court, and I thank you so much.
Judge Civilli has directed Lange's attorney to apply for admission to a drug court program. If Lange is not accepted into the program, he could face another jail sentence. Cleveland Browns player Dante Stallworth pleaded guilty to DUI manslaughter in a Miami court.
Express my deepest sincerities and condolences to the Reyes family and Mr. Reyes' daughter, Daniela. Your Honor, I offer my plea and I accept full responsibility for this horrible tragedy. I assure you that this tragedy will continue to bear this burden for the rest of my life. Though I cannot bring back Mr. Reyes or ease his family's pain, I can and will honor his memory by committing my time, my resources, and my voice to educating this community about the dangers of drunk driving. I understand the seriousness of these charges, Your Honor, and the significant expectations you, Mr. Reyes' family, and everyone else have for me beyond my plea agreement, and I will meet every one of those expectations.
The court's going to accept this plea. I've heard from everyone, and I think that it's appropriate under the circumstances. My concern for the minor child, the victim, has been satisfied today. She can go through anything more. The court finds the plea is freely and voluntarily entered into with the advice of competent counsel. The defendant is alert, intelligent, understands the nature of the charges and the consequences of his plea. The court further finds sufficient factual basis exists based on the stipulation by defense counsel, and the court review the arrest affidavit. The court accepts the defendant's guilty plea, finds the defendant guilty, adjudicates the defendant guilty, sends him to 30 days in Dade County Jail, to be followed by 2 years of community control, followed by 8 years of reporting probation. Special conditions during his supervision is to be a drug and alcohol evaluation and, if necessary, treatment, regular and periodic drug testing, a lifetime driver license suspension, no driving without a valid license, actually just no driving because he won't have a license during the period, no driving at all, $2,500 donation to the Mothers Against Drunk Drivers, $2,500 donation to the parents of murdered children, 100 community service hours.
1,000 community service hours.
Sorry, there's an extra zero there. 1,000 community service hours. Any other matters? If not, we are adjourned.
He was sentenced to a combination of jail time and probation. This is when a state trooper may have saved many lives on the Sunshine Skyway Bridge. Investigators say Trooper Tony Shuck intentionally positioned her SUV in the path of a drunk driver speeding toward runners in the Skyway 10K race. Trooper Shuck is now recovering at home, while the woman who crashed into her remains in jail. With only seconds to act and no time to move aside, Trooper Shuck placed herself directly in harm's way, using her SUV as a barrier to protect the runners on the bridge.
Was no time to think. You have to act. And without question, she was the last line of defense.
52-year-old Kristen Watts from Sarasota was driving the BMW. According to Trooper Ken Watson, Watts ignored road closures and sped past law enforcement as she approached the bridge. Another trooper tried to stop her by getting into position, but Trooper Shuck ultimately swung her SUV into Watts's path to bring her to a halt.
Telling what would have happened had that vehicle actually reached all of those runners. The bottom line is these troopers saved dozens upon dozens of lives.
Watts was brought into the Manatee County Jail in a wheelchair.
Need public defender.
During her first court appearance, Watts informed the judge that she had no job and was living off money from a lawsuit. Despite facing multiple charges, including driving under the influence, she was seen laughing in the courtroom.
Would you have any trouble coming to court?
Well, considering I don't have a car.
Trooper Shuck is now at home, resting with her family and recovering from a concussion after an incident. After 26 years of service, her actions went beyond the call of duty, reflecting the instincts of a true hero.
Trooper to risk her life to make sure that others would be okay is the epitome of what service is all about.
Watts remains in the Manatee County Jail on a $52,000 bond. The word hero hardly captures the bravery of Trooper Shuck's actions that day. Stuart Richardson had been arrested at least 9 times for drunk driving before his 10th DWI incident when he crashed into an Arlington family's vehicle. The accident tragically claimed the life of a young boy. The sentence was handed down, bringing relief to the victim's family and allowing them to begin moving forward with their lives. The district attorney's office expressed hope that the impact of this sentence will be felt widely and serve as a strong message.
The system in this country and those other states has played catch and release with this man for too long. He has stood before 22 judges, but he's never had judgment for what he's done.
Everything changed today for 51-year-old Stuart Richardson.
Find the deadly weapon to be true and assess a sentence of 50 years confinement in the Texas penitentiary.
The man with a criminal history that includes nearly 24 convictions across several states, including multiple DWIs, is going to prison for the first time. For at least one family, this brings a sense of relief.
I already did forgive you, and I have nothing to do with you after today. But wake up that conscience, get closer to God. Ask him for forgiveness. Ask Abdullah for forgiveness.
Abdullah Kader was riding in the back seat of his family's van in 2009 when Richardson crashed into them. Tragically, Abdullah passed away as a result of the crash. Richardson showed no emotion as his sentence was announced. His attorneys chose not to speak on camera afterward, unlike the family of his victim.
He got what he deserved.
Prosecutors expressed satisfaction with Richardson's 50-year sentence. He will receive credit for the time already served and could be eligible for parole when he is 76.
Mr. Richardson earned every day of that 50-year sentence. 22 prior convictions, 6 of them for alcohol-related offenses, 3 people seriously injured over 2 decades ago. If there's anyone who's earned time in prison, it's him.
Well, I hope what we did today, we got justice for the families that Stuart Richardson hurt before. My son, I don't think there's anything that can be done to get us justice for him. And I hope it raises awareness about drunk driving.
As you heard, the family believes that Richardson received the sentence he deserved, but more importantly, they are focused on keeping their son's memory alive. During the proceedings, it was mentioned that they had had another child, a baby girl, since the accident. While trying to move forward with their lives, they want to ensure their son's memory is never forgotten. The district attorney called the sentence a major accomplishment, but questions remain about how Richardson managed to avoid prison until now. Despite having 22 convictions, Richardson had never been sentenced to prison and had only spent about 45 days in jail. The prosecutor explained that because the crimes occurred in different states, each state considered the cases individually, and each time the decision was made to grant probation. A judge has denied probation for Emily Hall, who is serving a 10-year sentence after pleading guilty to manslaughter and other charges related to a 2007 alcohol-related accident that resulted in the death of a passenger. Judge Mary Willett issued a written decision stating that Hall's continued imprisonment is necessary to protect the public. The judge expressed concern that Hall might continue to drive under the influence if released, despite testimony earlier in the day from several people who said that the incident had profoundly affected her.
Prison has served its purpose for Ms. Hall. She has gotten an intense dose of what a nightmare prison can be.
Family, friends, and her attorney insist that Emily Hall has changed during her prison period. Despite this, the judge felt her continued imprisonment was necessary for public safety.
And so very remorseful for what I've done. There's not a day that goes by that I don't think about Mr. Reamer and his entire family.
Hall couldn't hold back her emotions as her attorney read the letters she had written to the judge who held her fate in his hands. Police reported that Emily's blood alcohol content was twice the legal limit when she lost control of her car in 2007 on the Lauderson Expressway. At the time, the then 20-year-old crashed into a semi-truck, killing its passenger. Just a few months before this tragic accident, Hall had completed a diversion program following a prior DUI arrest.
She is extremely remorseful for what happened. And I feel like that it's time for her to get some help.
She was given an opportunity by being placed in the diversion program to realize the serious nature of drinking and driving and to take appropriate action, and she didn't do that.
If released, Hall expressed a desire to speak to the community about the dangers of drinking and driving. However, prosecutors argued that the judge should instead use her case to send a strong message to the community and Hall herself.
This is a serious offense. When you make those choices, these actions can result in the ultimate consequences for someone else. Those choices deserve a 10-year prison sentence.
Judge Mary Willett agreed with the prosecutors. In his written decision, he referenced a pre-sentence investigation that revealed Emily Hall began using alcohol and marijuana. The PSI also noted that she would eventually consume up to 24 beers or a fifth of liquor daily. The judge stated that granting shock probation would undermine the seriousness of her crimes. As a result, Emily Hall's request for shock probation was denied. This incident centers on Brandon Castiglione. On October 1st, 2019, in London, Brandon ended the life of 60-year-old Minister Garcia at Brandon's house. When the police began their investigation, they quickly discovered that Brandon was responsible for the crime and subsequently filed charges against him. Brandon seized the opportunity to convince the judge of his innocence, with his attorney working diligently to establish his client's innocence in this case.
Brandon Castiglione is not guilty. The police jumped to conclusions. Within 2 minutes of the first officer arriving on the scene, Brandon was in handcuffs in the back of a police car. And because the police jumped to that conclusion, they did not do a thorough investigation. And as you've heard, they only looked for evidence that pointed at Brandon. I want to talk to you about some of the ways the police did not do a thorough investigation. Evidence that they should have collected, but that they simply did not. So, what did you hear about that? Well, you heard there was a cell phone right there on Brandon's bed. See multiple pictures of it. But you heard the police didn't collect that. You heard Trooper O'Leary testify about the kinds of information that can be on a cell phone. GPS data, calls, texts, all kinds of things. You heard him explain how they go about the process of applying for a search warrant, what they have to show, that it's likely that there would be evidence related to the case. They had Brandon as their suspect. His GPS records of where he was that day, of course the judge would have signed off for that. The police could have had that. All they had to do was ask. But you heard, they didn't bother. It wasn't part of their application for a search warrant. You never heard that any officer ever asked Brandon for permission. You did hear that's another way to search for a phone, or to search a phone. In fact, that's what happened with Luis Garcia's phone. The police searched that because they had permission. They didn't ask Brandon for permission. They didn't ask for a search warrant. They didn't bother looking for the most basic thing that was right there in front of them. Well, what other ways did the police not do a thorough investigation? Did the police not obtain important evidence and information that they should have? You heard when Mark Castiglione, Brandon's father, got on the stand and testified. He said he thought Brandon had a car that day, and then he wasn't sure, and maybe it was returned earlier, and he really didn't know. Why didn't the police find out back then whether Brandon had a car available? Whether Brandon could have gone for a drive? Whether Brandon could have gone anywhere? The police did nothing to investigate where Brandon was on October 1st. You didn't hear. You didn't hear any police officer tell you that they knocked on all the doors on that street, that they asked, hey, did you see anyone come or go from number 15? I mean, we're talking about basic things that you should have heard. Where was any evidence of any of that? The police did not do the most basic things in investigating this case. They didn't do it because, again, within 2 minutes, they had decided it was Brandon. He was in handcuffs in a police car. Now, I've explained to you how the police jumped to conclusions. The government wants you to jump to that same conclusion. You heard in the government's opening statement them say how simple this case is. One bullet, one man. One man that they can't put in the house at the time of the one man that they can't say that day. One man who had no reason to shoot his friend. What the government doesn't want you to think about is 4 very important words in this case. Beyond a reasonable doubt. You've heard that several times throughout the case. The government has to prove their case. Brandon doesn't have to prove anything sitting there. The government has to prove that Brandon did what they're claiming he did. They have to prove that to you beyond a reasonable doubt. I want to talk about those 4 words for a minute. You know, your jury service started actually before you ever saw Judge Ruoff. Started with that video that you watched first thing when you came in on jury selection day. And that video introduced you to some important legal concepts, including different levels of proof for different kinds of cases. One level of proof is called proof by preponderance of the evidence. Think of it as the scales of justice, and if they tip ever so slightly one way or another, that's proof by preponderance of the evidence. That's all it takes in some kinds of cases. But that's not the standard that you're applying here. There's another, higher standard that applies to other kinds of cases. Certain kinds of cases have a higher standard called clear and convincing evidence. That is not the standard that you are applying highest burden, the highest standard, I should say. that our legal system has. Proof beyond a reasonable doubt. And the judge has told you, if you have a reasonable doubt, you must return a verdict of not guilty. And I want to talk to you for just a minute about why it's that way. It's that way because of our constitutions, both the New Hampshire Constitution and the U.S. Constitution. And that standard was written into those documents. And the great scientist, statesman, founding father, Ben Franklin, said it far better than I ever could. So I'm going to read a quote from him. He said that it is better 100 guilty persons should escape than that one innocent person should suffer, is a maxim that has been long and generally approved. That's why it's written into the constitutions, for this highest standard, proof beyond a reasonable doubt. I want to talk to you about another important moment in this case, one you may not be thinking of. On Tuesday of last week, not at jury selection, but right before the trial began, on Tuesday afternoon, each one of you stood in that box. Each one of you raised your right hand, and each one of you swore that you would follow the judge's instructions. You took that oath. And the judge has told you, if you have a reasonable doubt, you must find the defendant, Brandon, not guilty. Now, the judge will tell you that your verdict has to be unanimous, and that's certainly true. He'll also tell you that your verdict has to be your own individual vote. And I want to talk about what that means for just a moment, because you don't all have to have the same doubt. If you doubt because the police didn't get the phone, if you doubt because Brandon had no reason to kill Luis Garcia, if you doubt because the police didn't test the residue kit that they took, if you doubt for another reason, that's okay. You don't all have to have the same doubt. If each of you individually has a reasonable doubt, your individual vote is not guilty. And if each of you vote not guilty, that is what is meant by a unanimous verdict. I want to talk about some other ways that the police did not do a thorough investigation. And that, ladies and gentlemen, one of the ways is the residue that they took a kit for, that they collected, never tested. You heard about the warrant for Brandon, for his body. You saw all these pictures, a couple dozen or more, documenting everything they did, documenting what he was wearing, documenting each layer of clothes they took off, documenting his hands. You heard. The police got a warrant for all of that because they knew it could contain important evidence. You heard they took swabbings of his hand for completing a residue kit. You heard that someone who will have residue on their hands. The judge signed off on that warrant. The police requested that warrant. They did that for a reason. And then they didn't bother to test it. Could have shown that Brandon didn't that day if they had just bothered to test them. But it wasn't just the residue kit from his hands that wasn't tested. It was also his clothes. All of those were collected. All of those were sent to the state lab. Those could have also been tested for residue. Again, could have shown if Brandon could have proved that he did not.
It was mainly, I wrote this already. It was addressing to the court, but I'd like to address it, with the family, the court. didn't know exactly how it was
You
going
can read it.
to proceed. So I wrote it addressed in court, but him as well. It was, I first want to express my sympathy and deep condolences for the loss of Luis Garcia. The last 4 years have been a tough time, not only for Louis and his family, but everybody that was involved in the situation. I considered and still do consider Louis a dear friend of mine. We enjoyed many things together, church, prayer, dinner together. It's a sad thing that this world brings to us. All we have to get through this is God and the people it brings to us. Sometimes I sit and question myself why certain things happen as they do. It brings me to a point that the fact that God has our best interests in mind. I know one day God will restore us and bring our hearts back together.
Thank you.
So I know, obviously, reading the state's memorandum about asking for, the sentencing and the factors of, what they consider to be true. The only thing I have to say about that is, I just ask the court, I guess, to trust your judgment to deem what is fair and right, based on the facts of what you believe. And I know they obviously the prosecutor and they're looking one way, and I know there's always sometimes different sides. I know normally the defense would be saying something, saying, we would want this or this or this, there's so many years, in regards and respect to what they're offering, they're offering 40 to life, and I'm assuming my attorneys were offered something, probably try to get lower. That's not what I'm really asking them. What I'm asking is, like I said, the prosecution has one side, and they're dealing with it from, one view, and I just ask, try to, and I know you will, and that's why I trust your judgment, that, just consider everything. And I'm not going to put a number out there because I'm not the judge here. I believe that you're fair in your judgment, so I'm just going to trust that and whatnot, wherever you deem is fair and right. That's all. Thank you.
The suspect's fate rests in the hands of the judge, who must ensure that the sentence is fair to the victim and their family when determining the appropriate punishment. In this case, the judge upheld this principle.
All right, Mr. Castiglione, would you please stand? And just for the benefit of those in the back of the courtroom, all my letters and all my stuff is electronic, so that's what I've been looking at up here. It's not staring off into space. I'm reading through the letters and everything that have been submitted electronically. Might not be obvious from back there, but that's what I've been looking at. As a judge in sentencing, I always try to figure out why something happened. And from there, I can usually proceed to figuring out how to address why it happened. Sometimes it's because of substance abuse, sometimes it's because of mental health issues, sometimes it's because of the personality traits of the people involved. And so I always am, at an intuitive level, drawn to trying to figure out why a crime occurred. And it doesn't matter whether it's shoplifting, it doesn't matter whether it's an assault or a possession of drugs. And as many have articulated much better than I have, or could, the question of why, in this case, just remains unanswered. And I've considered all the facts that I heard at trial in this case in trying to figure out what the appropriate sentence is without being able to answer the question why. And I think it's very unsatisfying for everybody in this case. I think there are a lot of people that would like to know why. family members, your sister sitting back there, would want to know why. I think it's just natural for us to try to understand how something happened. And we can't in this case, so it's left unanswered. When sentencing, the judge has to consider many factors. They're all outlined in the briefs. And I know that your previous attorney has made several objections to the PSI, which after reviewing the memo, I understand every one of the objections, and for the most part, agree with most of them. I'm not relying on the PSI in my assessment here. The facts I see, I kind of understand the trial a bit differently than I think the PSI narrative did. I've tried to define what I think are the characteristics in this case in fashioning the sentence. At the end of the day, I keep coming back to some facts that are, I think, very, very strong for the state. And that is a completely blameless, by all accounts, wonderful human being was by to his head of a kind of hollow point expanding at very close range from behind. Those facts speak largely to me about kind of how this was carried out, without answering the question why. I actually don't need an answer to the question why in this case. At the end of the day, it was the jury found you guilty of taking the trigger, going behind Luis Garcia and pulling the trigger and murdering him. There's no signs of struggle, no signs of forced entry. And your family and Mr. Garcia's family are wrestling with why. How did this happen? I know there was some evidence about some disagreements at Bible studies, but I'm not convinced that played into this. One thing I'm not considering in sentencing is the suggestion of the state that you took no responsibility for this. I wouldn't consider that as an aggravating factor or a mitigating factor or any factor at all that put the state to its proof. I also know that many of the family members were looking to you for some type of reaction and show of remorse. Sometimes I see that as the defendant, sometimes I don't. When I do see it, it means something to me. When I don't, I'm not sure how to interpret it, because I know a bit about you, Mr. Castiglione. I know you're on some, I'll call them heavy-duty medications, and sometimes that affects how people present and how they react to stress and how they look. It flattens their affect, and that's just a chemical process in the brain, and that may be true for you, it may not be true. So when I don't know, I don't automatically say it's lack of remorse. So I'm not quite sure. I know the family kind of talked about that, but I just want to explain why I don't personally attach as much significance to that, because I see many defendants who have no affect, and it's for reasons beyond their control. I am struck by the impact that this has had on the family. Clearly, the victim played a prominent role in his community. He played a prominent role in the lives of his family, and there's no way to replace that loss. And in that regard, he was unique among his peers and his family members. And I'm very much aware of what the victims have had to say and the family have had to say about his loss. And I really do empathize with that. It's very obvious. It's also remarkable to me that the family has an overwhelming level of forgiveness based on their deep religious faith, which quite frankly I find refreshing, because I don't see that all that often in this courtroom. A lot of compassion flows from this side of the aisle to that side of the aisle, and I think it actually goes the other way too, because there are no winners in this room right now. There are none. There's no one that's ever going to leave this room feeling good about themselves. I know I certainly won't. I've been a judge for a while. I've been a lawyer for almost 30 years, and I've handled thousands of criminal cases. I've prosecuted murders. I've defended murders. I've interviewed clients in jail. I've been on both sides, and I've seen a lot of cases. And this one is unique. This one's squarely unique. I can't reconcile how such a senseless act of violence happened, and it was extreme, which is an aggravating factor. The sentence I've decided is based on balancing all the factors that I have to consider: rehabilitation, punishment, specific deterrence, general deterrence. For the most part, I agree with the state about the weight to be ascribed to each one of those factors in sentencing. I wish I could say that this is a clear case of mental health issues. I did press the state kind of hard early on about that in this case. I know that there are some at play in your life, Mr. Castiglione, but I can't really connect them to how this played itself out, other than religious beliefs, which I agree with the state. I can't really find that that's a mental illness. There may be something there, I don't know, that explains this. So it's unmitigated violence and involving, and quite frankly, close range for the of a blameless victim. I think punishment has to weigh heavily in this case. I think deterrence on violence has to weigh heavily in this case. And also it has to count for what has been lost by the family in this case. Actually, both families, because he was a leader for both families. The sentence that I find appropriate after balancing all those factors and considering the factors is 42 years to life. And I chose that 42-year mark because at parole, that'll be, with the pretrial confinement credit, you'll be released at 64 years of age, which is the date, the age that Mr. Garcia would be on the 22nd of August. I think that's appropriate in this case. So when you walk out, maybe you'll pick up where he left off. I don't know, but I think that's an appropriate sentence in this case. I'm recommending to the jail that you be screened for drug and alcohol treatment needs, because I know you need them based on my review of the jail disciplinary issues. And I think that's the appropriate sentence in this case. I'm going to endorse that order. Sir, you have a right to apply for sentence review. That's a panel of 3 judges. They can increase the sentence, they can decrease the sentence, or they can leave it alone. The clerk, when I adjourn here, is going to give you that notice, and you can apply for sentence review. Your lawyers are going to have 30 days to prepare a notice of appeal, which they'll do on your behalf. And I'm going to do that order when I leave here, so that the attorneys have clear guidance on what they can and can't do for post-conviction relief. I think that's the appropriate sentence. Court stands in recess.
This case centers on Andrew Delkey. On July 26, 2018, in Nashville, Tennessee, former police officer Andrew Delkey took the life of Daniel Edward Hambrick. Following an investigation, Delkey was charged with the crime. Witnesses' testimonies played a crucial role in the case.
This is the preliminary hearing to determine if there is probable cause to bind over the warrant, State of Tennessee versus Andrew Delkey for criminal homicide. If there is found to be probable cause, the case will be bound over to the Davidson County Grand Jury.
Was Daniel Hambrick still on the scene when you arrived?
He was not.
Were there any officers on the scene when you arrived?
There were.
Okay. And where was Mr. Hambrick?
On his way to the hospital.
Was there another on the scene?
There was.
And do you know where that was located?
Where it was located?
Yes.
Yes, it was located at the base of the tree. When I saw it first, located at the base of the tree next to where Mr. Hambrick's body came to final rest.
The gun that was found close to where Mr. Hambrick's body was ever fired or discharged?
No, there was no indication that it was fired.
And I'm gonna pause it here. Do you see Mr. Hambrick on this screen?
Yes.
Okay, could you point him out for the court?
It's this subject right here in the dark shirt.
I'm gonna pause it here. Can you tell me what car just entered the screen on the left-hand side?
This gray car right here is Officer Delkey's car.
I'm going to shoot. So I explicitly told him, because at that point it had risen to the level already in my mind when the gun had been pointed at me already. he's refusing multiple commands to drop the gun, and now I'm explicitly telling him what the consequences of not dropping the gun is going to be, and he's refusing to do so. In my mind, at that moment, I knew 100% his intent was to use that gun against me, and maybe possibly somebody else. And I said, if I don't...
I am pleading guilty today because I recognize that my use of force was not reasonably necessary under all the circumstances. I recognize that what happened on July 26, 2018 was tragic. Mrs. Hambrick lost her son that day, and I am responsible for her loss. Excuse me. These are facts that I will have to live with for the rest of my life. And no mother should ever have to experience the loss of a child, and not a day has gone by that I have not thought about my actions. I also recognize that my actions impacted the community and the police department. I hope this case can contribute positively to the much needed discussion about how police officers are trained and how we as a community want police officers to interact with citizens. I am deeply sorry for the harm my actions cause, and I hope that Mr. Hambrick's family will obtain some comfort from my acceptance of responsibility and my guilty plea today.
We're asking you, the last one that we can come to, that we can turn to, Judge Rocky. You're it. The buck stops there. We're asking you to reject this plea deal, like judges do all the time, in the interest of justice, based on every shred of evidence you've heard, based on the fact that her rights were violated, and based on the fact that 12, but not however many were on the grand jury, strangers, decided that they were going to indict this man on a first-degree premeditated charge. We ask you that now. Thank you. Henry has something to say.
All right.
Because I've been through a lot from your
Ms. Hamburg.
You come, no,
Okay.
let me go.
Well,
Let me go.
well,
You talk about my family. Y'all talk about my family. Y'all call us.
I think that's enough.
Y'all say we eat watermelon. You racist. Y'all, no.
Okay. Don't harm anyone. Don't come up here. Just hold it. All right, we've gone through the plea colloquy. There's not much left to do, but here we are. All right, I find you guilty. I find there's a factual basis for the plea, and that the plea is freely and voluntarily given. In case 2019A26, I sentence you to a term of 3 years as a standard range 1 offender. That sentence is to serve. There will be no petitions for early release, and that'll be it. All right.
Thank you. Thank you.
Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.